We now come to Clause 2, commencement. This is a very narrow debate. The question is that Clause 2 stand part. I call Chris Hipkins.
Thank you, Mr Chair. I'm very happy to take a call on the commencement clause for the New Zealand Public Health and Disability Amendment Bill number 2. And yes, indeed, this is a very narrow debate. It concerns when this legislation will come into force, and we all need to consider, first of all, in discussing that, the context under which this bill is being debated. It's being debated under urgency, and in the contents of this bill, it basically removes the right to a judicial process for a group of New Zealanders. So therefore the date on which it comes into force is actually very significant. It's being pushed through under urgency basically to prevent anybody else using their right at the moment under current law to seek, to use a judicial process. So this bill is being pushed through to stop further claims being made, and that's why we're here under urgency debating it. So let's talk a little bit about the commencement. This Act comes into force on the day after the date on which it receives the royal assent. Well, there's many aspects to this particular clause that are of a slightly more technical nature, but the day after the date on which it receives the royal assent is pretty ambiguous, because actually we don't know when the Governor-General is going to sign this particular piece of legislation. So in our constitutional arrangements, the royal assent is exercised on behalf of the Queen, the head of state, by the Governor-General. So first of all, the first question is we need to know when the Governor-General is available to sign it. And in fact, of course, there's no guarantee that the Governor-General will sign it. In our arrangements, there is no obligation. There's no concrete obligation on the Governor-General to sign any legislation that this Parliament passes. And in fact, part of our Constitution is the never yet exercised right of veto on the part of the head of state to veto legislation that this House might pass. It hasn't happened in the New Zealand context, but it has indeed happened in other contexts. And what might happen if the head of state decided to refuse to sign something? And there's a very interesting example of where this happened, and it was in Belgium. And I was recently visiting there, and what had happened is the King had refused to sign the King had refused to sign a piece of legislation to give it the royal assent, and therefore the Belgian Parliament was forced to work out how they might get this particular piece of legislation in the absence of the royal assent. What was the grounds for the refusal of the royal assent? The King had refused to sign it on the basis that the legislation being passed, I can't remember what it was, but it was of a nature of the sort that we would have a conscience vote on in the New Zealand Parliament. The King had refused to sign it on the basis that it violated his own conscience. So even though the Democratic Parliament had passed the legislation, the head of state decided, well, he could exercise his conscience on it as well and refused to sign it. And so that creates some interesting sort of constitutional issues there. And so the Parliament effectively utilised a little-known mechanism that allowed them to remove the head of state for a defined period of time. In this case, it was only for the period of time that was necessary for the Prime Minister, because if there's no head of state, then the Prime Minister could sign the legislation. So they removed the head of state for the duration that it took for the Prime Minister to sign the legislation instead. And that's how they got what was the equivalent of the royal assent for that particular legislative measure. But in New Zealand, it's a little bit less clear what would happen to a piece of legislation if, in fact, the head of state or the Governor-General refused to sign it. It hasn't happened in New Zealand's history, and I think that's something that's quite interesting, because it's very possible that the head of state in New Zealand could look at this and go, well, this legislation, which removes the right to a judicial process, to a legal process from citizens of New Zealand, has been passed by Parliament under urgency without according it the usual legislative process. So we've got two issues here. We've got the issue of people's rights being taken away, and then we've got the issue of the correct parliamentary process, where the public and people of New Zealand have a chance to have a say. That is also being taken away. So those two things could together compound the head of state or the Governor-General's concern, and the Governor-General or the head of state, the Queen, may refuse to give this legislation the royal assent. I think that's pretty unlikely, because, like I said, never happened before in New Zealand's history that the royal assent has been refused. But it's a really important principle. The principle that New Zealanders have the chance to have a say on legislation that impacts on them. There is no good reason why this legislation couldn't go to a select committee even for a shortened period of time. And in fact, there has been precedent in the Parliament where legislation that needs to, Mr Chair,
Chris Hipkins.
Legislation that needs to have immediate effect can have a clause inserted into it that it would come into effect from the day that it was introduced. So even if it was introduced, I think yesterday, well, which is actually today on the parliamentary urgency system. Well, that's right. In the real world, it's Friday. In the parliamentary world, it's Thursday. So it's still Thursday here. So this legislation was introduced today. In the parliamentary world, which is yesterday for everybody else in the rest of the country. So the legislation introduced on Thursday, let's just say on Thursday to avoid confusion, if we were to send it to a select committee, it could have a clause in it that said, once it had been considered by a select committee, brought back to the House and went through this process that we're now doing, the committee stage process, and then passed third reading, and then given the royal assent, then it would come into force, at that point, it would come into force backdated effectively to the date that it was introduced. That has happened before in the House. So therefore the idea that this legislation removing New Zealanders' rights needs to be pushed through this House under urgency is seriously diminished, because there's another way the government could achieve that. So therefore, the head of state could look at this and say, well, those two things, the removal of citizens' rights and the bad process that the government are using to do it, could be sufficient for the head of state to look at it and say, well, I'm not going to give this the royal assent. And could they then send it back to the House? They could send it back to the House and say, well, I want some evidence that the House, that this Parliament has gone through a sufficiently robust process in passing the legislation. I think that probably would be quite a good thing if they did that. But then again, it might create some other issues around the separation of, or the appropriate balance of powers. But the issue that we have here is that there really isn't a good justification, and one of the reasons the Labour Party is voting against this legislation is there isn't good justification for pushing it through all stages under urgency in the way that it is, and not supplying the public, the New Zealand public, the people whose rights are being taken away by this legislation, the chance to make a submission at a select committee and to talk about it. What tends to happen with bills like this is there will inevitably be a mistake in it. We know that because we're about to debate, after we've done this, changes to the Crown Minerals Act, which the government only amended literally weeks ago. It's barely been in place for a number of weeks, and we're going to be amending it because they stuffed it up. And that actually, I think, that did go through a select committee process, and they still managed to stuff it up. This hasn't gone through a select committee process. So we could be back here. We could be back here in no time debating we may be back here later in the day, given the way Parliament works, fixing up a mistake in this legislation because it hasn't been given scrutiny. There is not one piece of legislation that's gone to a select committee that I've been a member of that hasn't in some way been improved by going through that process. That's one of the reasons why we have select committee process, so that we can adequately examine legislation and so that we can make sure the government's doing its job. Now, how can we do that adequately? How can we discharge our functions as a parliament when things like the regulatory impact statement are mostly blacked out? So a regulatory impact statement designed specifically so that the Parliament can ensure the government is exercising its responsibilities and doing its job appropriately, and we are being denied that information. And that is another reason why the head of state could look at this legislation and refuse to give it the royal assent, because due process has not been followed. Parliament is not following its own rules. By passing legislation without due scrutiny, if I'm going to ask Grant Robertson to pass me the piece of paper, the regulatory impact statement sitting in front of him, a very good piece of legislation, with a regulatory impact statement that looks like this, where no one can actually read it to make sure that we're doing our job appropriately. Those are good grounds for saying that this legislation should not stand. It's being passed by the narrowest of margins. That last vote that we had on the first clause passed by the narrowest of margins in this House against the will of the very significant minority, but also in the process shutting New Zealanders out of this process. But that's what New Zealanders have come to expect from this government. That's right. That is what they expect from the born-to-rule Tory arrogant government. More and more They're willing to ride roughshod over the democratic process, over the rights of New Zealanders, and they laugh about it because they think it's funny. They think it's hilarious that New Zealanders won't get a chance to have a say on the legislation that affects them and that removes their rights. That is wrong. That is fundamentally wrong.
The Honourable Ruth Dyson.
Mr Chairman,